that said, let me begin with a disclosure of my own. This is DISS, and my strategy to avoid getting dissed will be to keep this as short as possible. I very much hope that you will also find it sweet. But you know, when I think about information disclosure, and when I talk about information disclosure, this is very much from the perspective that I come from. It is disclosure of new information, particularly disclosure of information about innovations. So the presumption is that there's new knowledge, proprietary knowledge, that is getting disclosed to other parties. So whatever I say from here on will implicitly assume that feature of disclosure to be true, which is that disclosure refers to the putting up or publication of something new that is proprietary, right? So then when we think about such information disclosure, there's generally a fundamental paradox around disclosure. One is, that it's very much like a double-edged sword. And so on the one hand, disclosure of information reduces asymmetric information. But when you're reducing asymmetric information, you're reducing the information asymmetry to not only your potential friends, but also to potential rivals. So you're also informing rivals. So likewise, as a consequence of this, as a benefit, while information disclosure can help you attract external resources by informing potential partners, suppliers, customers, investor, and so on, you can also expose yourself to expropriation risk by potential imitators. Likewise, in terms of kind of a more social sort of effect, social welfare effect, when you are disclosing your stuff to others, because you're informing others who might be wanting or might have independently thought of coming up with an idea similar to yours, might also be deterred. So information disclosure can be socially efficient because it prevents duplicative entry. However, yet for others who may still be convinced that they want to enter and duplicate your ideas, you may be lowering their cost of imitation, right? So then overall, then the effect of information disclosure could be either to enhance learning, make R&D more efficient by disclosing or by preventing duplication and by helping follow-on learning. But it could also have a perverse incentive if the person who is supposed to disclose, because the costs exceed the benefits of disclosure, is prevented from creating new knowledge in the first place. So basically then disclosure can, under certain situations, reduce incentives to invest in new knowledge and in innovation. So basically there's these kind of, two edges to the sword. And in my view, which side of the sword comes into play and cuts through entirely depends on the context. The context in which I have primarily done my research is in the context of patent disclosure. So what happens with patent disclosure? As all of you here know, a patent confers temporary monopoly rights once it is granted. However, in return for the grant of that monopoly right, inventors are also supposed to disclose their inventions and lay it out to the public. And basically, this is what an invention disclosure through a patent looks like. Here's basically a disclosure of the classic electric bulb that Thomas Alva Edison came up with. If you actually read it, even a relative duff like me can really understand what the genuine innovation here is. In particular, Thomas Alva Edison goes to great lengths to lay bare what were considered as the two fundamental challenges of electric bulbs at that point in time. The first challenge was really coming up with this filament that when electricity was passed through it would have sufficient resistance that it would light up. And the second was that instead of getting basically burnt out through oxygenation, it would remain lit up for a long time. These were the two fundamental sort of challenges that inventors of the electric bulb were grappling with at that point in time. And Thomas Alva Edison was very famous for his trial and error method before he came up with that filament, final filament, he had basically conducted over 1,000 experiments. So here he lays bare the consequence, the outcome of all those thousands of trials and errors, and says, okay, here's the particular material, a carbonized wire that he was using to light up the electric bulb. And second, he describes a new innovation he came up with, which was a vacuum pump, which would basically suck out all the air from the atmosphere of the bulb to maximize the time that the filament would stay lit up. Obviously, as soon as this was published, several other inventors who were working on the electric bulb took these two things as a given and started coming up with their own more efficient electric bulbs. So basically, Edison, by laying bare the key sort of ideas behind his electric bulb, arguably also facilitated knowledge diffusion that happened and promoted the entry of competitors. So basically, this is what basically is the key thing that we focus on in my different studies, which is what happens when you disclose an invention through patents. Previous to sort of some of the work we did, the general presumption among the legal scholars who had considered patent disclosure was that patent disclosure doesn't have so much of an effect in either promoting R&D spillovers or in any of the other effects that we consider. So the default sort of assumption was that patents were not performing their disclosure function. Okay, so we've, along with my various co-authors, looked at different aspects of patent disclosure, and what I will be describing for the rest of the time here will be results from a bunch of my studies, 3 of them published and a couple of them works in progress. Obviously, all this all the studies draw on a key sort of legal change that the US experienced in the year 2000 called the American Inventors Protection Act that we exploit to try and estimate the effects of patent disclosure. So prior to this act, the American Inventors Protection Act, all patent applications at the USPTO, the US Patent Office, were published only when the patents were granted. So basically, if the patents did not get granted, the applications were never disclosed. So typically, the length of patent protection is 20 years from patent application date. So before AIPA, all patents were published only upon grant. And typically, grant took about 3 years or 36 months on average. So basically, there was a period of time when the inventions in the patent applications were kept a secret, about 3 years on average. The American Inventors Protection Act required that all applications filed at the USPTO be published 18 months from patent application date. Okay, so this was the key law change. And so basically, as you can see, for the average patent, it reduces the time of secrecy in half. And this is basically the law change we exploit in exploring the effects of accelerating disclosure through patents. Now, the reason why the law was passed in the first place was part of the General Agreement on Tariffs and Trade, according to which there was a push towards harmonizing the patent systems all across the world. So prior to the American Inventors Protection Act, pretty much in all parts of the developed world, including in Europe and Japan, 18-month disclosure was mandatory. So it was not like the US implemented something new. It was only harmonizing through AIPA its own systems with the rest of the world, okay? This in turn also gives us an opportunity that for a certain set of applications that are filed both in the US as well as elsewhere, disclosure at 18 months was basically kind of happening through one channel, which is the foreign country channel before the passage of AIPA. And that's something we're going to exploit heavily in many of our studies. So this is the core sort of law. I must also mention, almost everything that I have learned on the American Inventors Protection Act and more broadly about disclosure has been through incredible conversations with my collaborators. And basically, at least a couple of them are here, Hong and Chengxi, to take all the difficult questions that might come up later on. But this is kind of my team that has really kind of, enhanced my thinking on the topic. So, there's also been a lot of related literature on the topic. Obviously, as you might expect, the topic of sort of disclosure has been exploited theoretically or explored theoretically for much longer than it has received empirical scrutiny. So there's kind of a lot of literature dating back to Arrow's information paradox, kind of, and that has looked at the different aspects of patent disclosure. More sort of recently, there have been kind of surveys that have asked companies about the pros and cons of disclosure through different mechanisms, as well as, Bernard has done some work here and others have as well, evidence from secrecy orders, trade secrecy laws, and so on. And there has been some recent work on assessing the effects of AIPA as well. Okay, so basically, what do we know from what we think are the effects of the American Inventors Protection Act? The first paper that I undertook looking at AIPA was with Stu Graham, published in Science in 2015. So here we were trying to understand when inventors are given the option of disclosing through patents, do they disclose or do they not disclose? And the reason why we thought it's a worthwhile question to explore was that the presumption was that when you come up with a new innovation, you are trying to keep it proprietary, the knowledge, the know-how behind the innovation secret for as long as possible. There was an article in The Economist: to patent an idea, you must publish it, but many firms prefer secrecy, okay? And then consistent with this, when the American Inventor Protection Act was proposed, 25 Nobel laureates basically sent a letter to the US Senate saying or arguing against early disclosure for US patents. And their sort of presumption was that particularly the small inventors would stand to lose because as soon as they disclosed their inventions, firms with superior resources would come in, copy or invent around what they had, and benefit from taking their inventions to the public or commercializing them. So basically, they were proposing that the US not adhere to early disclosure as the rest of the world had already signed off or even had in practice. So basically then, in response to intense lobbying in the US, the American Inventors Protection Act, in addition to requiring 18-month disclosure, also provided a loophole. And the loophole was that if, as an inventor, you agreed to give up foreign protection for your inventions, you could still disclose on the earlier timeline, which is postpone disclosure up until grant of your patent. So basically, this was an ad hoc loophole provision that was created to protect inventors who would feel a threat from other larger competitors if they were required to disclose their inventions 18 months after application date. So basically, this in turn allows us to basically kind of examine the revealed preferences of inventors after the AIPA law was passed. So basically what we do is we look at the preferences of inventors before AIPA, where inventors had two choices. If they filed for foreign protection abroad, then the invention would be disclosed through the foreign patent offices before, or basically if you were only filing the US before AIPA, then basically you could you could keep your applications a secret until grant, on average, up until about 3 years. After AIPA, though, obviously, if you decided to file in foreign countries, then you still had to disclose, at 18 months. Now, the choice of filing foreign is is basically available to you only up to an year of filing the first application in that family. So effectively, you have to make the decision of filing foreign before the 18-month disclosure sort of date binds on you. So basically, that's something to kind of keep in mind. But basically, after AIPA, you have that choice. You disclose at 18 months if you file foreign. Or if you don't file abroad, then you have two options. One is to disclose at 18 months, and the other is to postpone disclosure up until the grant of your patents. So what we do is we look at inventors and what they do after AIPA to infer their preferences for disclosure over secrecy, particularly focusing on those who really do not have to disclose because they're also pursuing foreign protection for their inventions. And basically, here's what we find. The propensity to seek foreign protection before and after AIPA does not change much. So about half of the applications seeking protection in the United States also seek foreign protection, either in Japan or EPO or in other places. That doesn't change before and after AIPA. But for the set of patents that are only applied for in the United States, what we found, which, to be honest, even surprised us, was that a majority of them were opting to disclose before grant, which is at 18 months. And this is something that really kind of struck us, that a majority of them, and this is kind of a fairly big majority, even when they don't have to, or even when they do not file for foreign protection, are choosing to disclose at 18 months from application date. Okay, so that's kind of the first result. And then we tried to look at industry variation in this propensity to disclose. And here we found that overall, in all industries, the overwhelming preference of inventors is for early disclosure. However, secrecy, the propensity to delay disclosure up until grant, varies across sectors, with computers and communications patents in these spaces being about twice as likely to delay disclosure relative to inventors in seeking patents in spaces like drugs and medicine and chemical and so on. Okay, so that's what we found. And then what we found, this is with reference to the Nobel laureates' concerns that the smaller inventors who did not have the complementary assets to commercialize their inventions would be the ones who would have a higher preference for secrecy. What we found was that it was actually exactly the opposite. The vast majority of small inventors were the most likely to opt for pre-grant disclosure or earlier disclosure. However, the preference for earlier disclosure was evident in all different inventor types that we looked at as well. One of the most important things that we found was also that the more important your invention is, and we use different measures of invention, the more likely you were to prefer disclosing early at 18 months. So the most important inventions pretty much were almost, an overwhelming majority of them were likely to adopt or prefer earlier disclosure, even when they were not filing for foreign protection. This is basically looking at percentiles of importance based on citations, even for adjusting for the additional exposure that patents that are disclosed early have. And what we found was that basically, if you're in the 95th percentile and above of quality, only about 4% of the patents in that sort of quality percentile are likely to postpone disclosure until later. Okay, so that was kind of the first result. And so that was kind of the first sort of stab at looking at inventors' preferences for disclosure and finding that, at least with patents, inventors prefer disclosing early. Now, the question arises, why? Why are they likely to disclose early? And my paper with Hong, who is here, tried to look at least one of the reasons why inventors, especially the smaller inventors, might prefer to disclose early, which was basically looking at this mechanism of licensing in the markets for technology. Okay, so it turns out when you are trying to license patents, typically the profits that you make are critically dependent on the length of time up until which you are able to get revenues for licensing your patent. And typically, the length of time up until which you get revenues are a function of the term of the patent. Okay, so all else equal, the sooner you license your patent, the longer your time period of revenues. And in some technologies, annual revenues and the share of the licensor's revenues can basically amount to $3 to $5 million in royalties and so on. So basically, this is one reason why you might want to license out your application early rather than late. However, there are the standard sort of caveats around disclosing or licensing out early, which is licensing it out early, especially before the grant of patent, might increase yourself to or open yourself up to increased expropriation risk. It might also sort of, basically kind of increase some of the other costs of finding suitable licensees and so on and so forth. So basically, there's a trade-off when it comes to licensing patents. You either wait until the patent is granted, in which case the expropriation risk is minimized. You've had enough time to really identify the most suitable sort of licensee for your innovation, versus basically the trade-off, the positive benefits, the benefits of licensing early, which is really that you can benefit from a longer stream of royalties. So basically, kind of you have this kind of two options. Then once you have a patent application, obviously you can try to license out the application right away. And if you don't do it, you can either wait until patent publication or really wait until patent grant. And this is kind of the choice we model in this paper. So basically, we derive some predictions to discipline our empirical examination. And we actually find some very interesting sort of insights. Thanks a lot. Hong really kind of pushed on some of the very subtle sort of effects, suggesting that disclosure might not always necessarily expedite sort of licensing, right? These are some of the things that we take to the data. And the data that we use here are primarily from RECAP, which gives us data on the timing of patent licenses, as well as some of the terms of the license. And RECAP data, in turn, is derived from the disclosures, the SEC disclosures of publicly listed companies, okay? And so basically, kind of each of these licenses that we looked at had about 2 patents on average, and we used the disclosure and grant dates of the earlier patent because we thought that would be kind of the driving force influencing the timing of these licenses. So basically, kind of what we find, and here's kind of the main figure, is that this is the histogram of the timing of licensing before AIPA. And what you see here is that before AIPA, most of the patents were likely to be licensed right after grant date. There's this big spike up in the hazard of licensing, the probability of licensing after patent grant date. So this is basically centered at 0. This is the lag between patent grant and licensing. What you see here after AIPA is that much of the mass of the licenses are shifted to occur much before patent grant date. Okay, and these spike ups are primarily around the 18-month disclosure date, which is more clearer here. What you see here is that after AIPA, there's a big spike up in licensing around the patent disclosure date, which is about 18 months. So this is kind of the big result, really, which is that before AIPA, about 62% of the patents were licensed after issue or after grant, whereas only about 37% of the patents wait up until grant to be licensed after AIPA. Okay, there are other more kind of subtle effects, but basically what we found was that overall patent publication accelerates the timing of licensing. and therefore favors inventors who might want to be kind of traders in the markets for technology, selling their ideas off. And one of the mechanisms that we provide evidence for is basically that earlier disclosure promotes faster licensing by reducing the search costs of finding the right licensee for your inventions. That was and we also find that these effects are stronger if you're a smaller inventor, if you're a not-for-profit inventor, such as a university, and inventors generally associated with higher information asymmetries and so on. Okay, so consistent with this sort of result, a couple of papers that I'm currently working on, one with Chengxi, who's also here, another with Boyan, is really kind of highlighting the private benefits of earlier patent disclosure. One, capital sort of market efficiency channel, which suggests that private sort of price discovery of smaller firms that are trying to bring to markets some of their key inventions happens more efficiently after patent disclosure. This is basically through the stock market reactions of the publicly listed companies that we find this evidence. And another paper where we provide another sort of kind of explanation or reason to rationalize these early patent disclosures, which is that early patent disclosures might be serving as signaling mechanisms where some of the better quality inventors credibly signal the high quality of their ideas and their ability to convert them into products by disclosing early. So these both of these highlight again some of the private benefits of disclosure. And finally, one of the papers in which we kind of look at some of the broader effects of disclosure, particularly kind of the larger innovation effects, is the JPE paper coming out this July with Kyle and Chengxi, where we use AIPA to basically kind of look at sort of what does the earlier news shock that AIPA entails in terms of informing other related inventors of related inventions do on the overall rate of innovation, as well as other things like duplication of R&D and so on and so forth. Even if you're not familiar with patents, think of AIPA as providing a new shock, right? I mean, previously we all used to learn about others' research once they were published. But now through mechanisms like NBER, SSRN, we basically get news about related papers much sooner than used to happen before. And so what we are trying to model here, the model is fairly general, and I think its insights can apply more broadly to disclosures other than those happen through patents, is understand what happens as a consequence of expediting or accelerating this new shock, in the sense that it basically clarifies uncertainty about the competitive landscape much earlier on than before. So this model then kind of gives us some good predictions, again, to discipline our empirical examination, which we do by basically looking at the before and after effects of AIPA, but also now with a control group where we use twin applications, which are applications that were also seeking foreign protection in foreign countries, both before and after AIPA, and therefore had to be always disclosed at 18 months from application date. That's kind of the counterfactual group that we use. And what we find here, basically, kind of these are some of the predictions, basically, is that this is kind of the first sort of shock. Here's kind of the counterfactual group of patent applications that were filed in US as well as abroad, okay, before and after AIPA. And here's basically kind of the applications that were disclosed only in the United States, therefore did not have corresponding foreign applications. And all this data is pretty much at a very granular level, happening at a monthly level. And so what you find here is basically the first thing that citation lags of US patents, right, basically kind of go up after AIPA, okay? So just to be super clear, I think, right, these are the patents with equivalent US foreign applications as well. And these are the patents that are disclosed only in European patent sort of offices. So basically, what we are picking up here is the effect of differential exposure only through the US Patent Office, okay? And what you find here is a very sharp pickup or a decrease in the citation labs, a pickup in the acceleration of citations here that you see after AIPA. So that's kind of the first effect, evident for 1 forward citations, 3 forward citations, 5 forward citations, and 7 forward citations as well. The second thing we look at is what happens to the number of citations. This is the extensive margin, if you will. And basically the idea is that after AIPA, a piece of knowledge is more likely to get used because it is disclosed sooner. It's not a mechanical effect because the exposure clock we set to disclosure date, both for pre-AIPA and post-AIPA patents, as well as for the counterfactual patents, so that we are not finding higher citations because you have a longer time window. So basically, this is fixing for the exposure date. You are getting an uptick in the extensive margin for post-AIPA patents because more recent knowledge is more relevant and therefore is more likely to get cited. Okay, so basically that's what these graphs are picking up. So that's kind of the primary thing we see here. An increase both in the intensive and extensive margin of citations after AIPA, indicating both more knowledge diffusion as well as faster knowledge diffusion. Now, here's kind of some of the interesting effects. Basically, what happens when you get to know about related inventions sooner is that if you are developing a close substitute, then instead of putting in more money, you say, okay, here's an invention that looks very similar to what I am doing, but they have a head start. And so I'm going to withdraw my sort of, R&D in that area. So basically, there's an effect where if you are a very close competitor, but just slightly behind, you're going to basically cut your R&D out and move on elsewhere. So there's a reduction in duplication. But at the same time, if you are working in peripheral areas, rather than now having to reinvent the wheel, you basically learn from what is disclosed and basically incorporate that in your work. So basically, there are two things happening with earlier disclosure, which is that the closer substitutes drop out and the farther sort of complements get closer to the inventions that are disclosed sooner, because now rather than reinventing the wheel, you use the knowledge that is disclosed as an input. So what we find here is that the similarity between really close patents decreases after AIPA, consistent with reduction of duplication, but the distance between farther patents, basically drops, or patents that were farther off in space get closer after AIPA because of the learning effect, the knowledge diffusion effect. Okay, so we look at some other things here. One of the key questions is about then what AIPA is doing overall to the intensity of patenting. Now that you are pushing inventors to disclose sooner, could there be a welfare loss if some folks are even choosing not to patent their ideas? Okay, and what we find here is no evidence for a decrease in patenting after AIPA, suggesting that one of the things which is kind of folks shifting out of patenting is not happening because you're forcing them to disclose sooner. This could very well be that because after AIPA, for the set of inventors for whom disclosure or disclosing early was very costly, you are still preserving the option of giving up on foreign protection and still postponing your sort of, disclosure. So that's there, but conditioned on that, we see no evidence for a drop in patenting. We do a ton of robustness checks. I won't go through them. but we also look at the effect of AIPA on R&D investments, a very important sort of aspect, because this is a measure that is outside of the patent database. And what we find is that basically kind of post-AIPA, there was about a 4.2% increase in R&D overall, which we attribute for a more efficient R&D process due to a combination of reduced duplication and lower cost of innovation, because now you're learning rather than having to do your own R&D. Okay, so basically kind of suggesting that earlier disclosure that is happening through this particular law change increase the efficiency of R&D. So overall then, what we find is that patent disclosure offers both private and public benefits. Of course, there are costs, but some of the effects that we find are net of the costs that we try to model either explicitly or implicitly, both in our theoretical as well as empirical analysis. So patent publications' effect on reducing the cost of innovation through knowledge diffusion seems to dominate the possible losses through increased imitation because of earlier disclosure, okay? And that some of the other private benefits could be basically competitive deterrence that happens through signaling, as well as higher licensing revenues through earlier licensing that might particularly benefit those without the complementary assets to develop and take their own inventions to the market downstream. And this is a very sort of timely sort of discussion, at least, in the sense that there are many legal proposals up there that want to scale back on the extent of disclosure that the patent law generally requires. So our sort of results seem to provide evidence, at least against some of those radical policies that are seeking to either delay disclosure or reduce the quality of disclosures that are up in the as proposals in the US sort of system right here. So that's basically what we find. However, we think of this as just a starter in terms of what can be done in terms of disclosure. One of the key things we have done here is examine disclosure through patents, which is a very strange beast, because when you're already applying for patenting, you are limiting the downside of disclosure through the grant of property rights. So basically, it is not like open skies disclosure, right? Because you're saying, okay, you can sort of publish your idea, but you get some form of rights. So there is a lower bound on the losses of disclosure imposed through patent disclosure. So thinking hard about how patent disclosure is different and how kind of other sort of intellectual property protection regimes interact with the patent system is kind of a very exciting area. I know Bernhard and others are kind of working on some of these topics. And secondly, kind of thinking about kind of, preferences for disclosure, how kind of aspects like corporate structure, culture, and other kind of maybe even softer features might have an effect on disclosure strategies might be interesting and important as well. As I bet it could cover kind of a lot of variation in the preferences for disclosure and disclosure-related appropriability mechanisms as well. And obviously, kind of the holy grail is to think about the longer-term effects of institutions that affect kind of disclosure related policies on things like firm-level competitive advantage, industry dynamism, and innovation, and so on. Let me also make a plug, right? I mean, actually, kind of, I have to sort of put in a proviso to my earlier prepared statement that this area in general has an extreme deficit of great empirical work to when you compare it to theoretical work. That said, I mean, again, I mean, today's theoretical presentation kind of lead me to sort of question that sort of characterization. But the reason is very simple, which is that with empirical work, you are trying to make judgments about disclosure by using counterfactuals, which you never get to observe, right? What is disclosed, you don't see. And then that poses a massive challenge, either with redactions or inventions, to what conclusions you can draw by looking at sort of at the margins what is happening with things that are getting disclosed. So that's always been the reason. However, I think creativity, a combination of creativity and great sort of data from past law changes are possibly kind of changing this. So I think this is a very, very exciting sort of field to work on. With that, let me conclude my remarks. Thank you for this opportunity, as well as for the great set of papers that were presented today, and open things up to questions.